I turned my laptop towards the deck so he could see the snow that's
Yep,
still
I saw that. You
out
know we're
there.
live now.
Not yet.
Mine says live.
Oh, really?
Yep.
Uh, well, that's weird. I've got a picture of the courthouse. I'm going to hit play. What happened? Did you hear that?
No, what did it say? I didn't.
It's playing an ad. I don't know what happened,
Oh,
but I gotta mute it. There we go. Uh, all right. I'm hopefully we're live streaming now.
yep, mine says up in the corner live, so.
Live on YouTube. Okay. All right. I'm going to bring in, let's see, Bray Miller. DeBrucker. Okay, we are now on the record since I don't have opposing party present. In the matter of Braymiller versus Hayford, Mr. Braymiller is present and his attorney, Mr. DeBrucker, is present. So often what happens in a custody matter is a order is recommended as a result of a conciliation process. Mr. DeBrucker, do you know if anything like that has occurred here?
Well, we do have a temporary order in place right now regarding the custody and parenting time, which does recommend joint legal custody with my client having primary physical custody.
Did either party object to that?
No, Your Honor.
Yeah, I don't know what's happening with our friend of the court conciliation system, but what they're supposed to do in a custody case as opposed to a divorce case is that instead of issuing a temporary recommended order, they're supposed to issue a final recommended order. And if neither party objects to it, that becomes the order going forward. So I'm going to have to talk to somebody. And this is beginning to happen more often than not. But if both parties are okay with the permanent custody order, all we can do a simple stipulation and order that says that becomes the final custody order. There wouldn't be a need for you to show up at a trial or present proofs.
Right, I would agree, Your Honor. I would say the defendant has been a little difficult to pin down. She hasn't been present at any of these hearings, it appears. She wasn't present at the last hearing on our motion to clarify the order. She received the same scheduling order that we received, that, she could be found in default should she not show up to this pretrial. And so at this point, I would, move for default and just have this interim order become the final order.
I will grant that request by reason of her failure to appear today, based upon the representation that the parties have both found this temporary order to be mutually acceptable. I will enter an order by default by reason of her failure to appear today that provides that the temporary order is now the final order of the court.
Thank you, Your Honor. I think that's the best thing to do at this point.
All right, I think you should submit that under the 7-day rule so that she at least has notice of it.
Absolutely.
If I'll remove the trial date, and if she doesn't file an objection, which sounds unlikely that she would, I'll just sign your order and that will become the final order.
Great. Sounds perfect to us, Your Honor. Thank you.
Okay, very good. You're welcome. Have a good day, gentlemen.
You too. Thank you.
You too.
Okay, Mr. Lopez, before I call the next case, I just wanted to let you know I was able to complete a pretrial conference with attorneys off the record. So your attorney was supposed to get a hold of you and let you know that, but in any event, there's no need for you to wait around. So I'm going to remove you from the hearing. Okay, next up is the matter of Hale versus Hale. And you are Christy Hale.
Yes, sir.
So Ms. Hale, this is just a simple divorce action without minor children involved.
Correct.
And what I decided a pretrial is whether or not it's necessary to have a trial. And sorry, I got distracted because I see somebody else is logged into my waiting room, but I see that's on the next case.
Okay.
Do you and Mr. Hale have any property in common?
We own a house together, which I'm living in and making the payments on.
All right. Well, that's obviously something that's going to require either an agreement by the two of you or a decision by me as to who ends up with the house and under what conditions.
Okay.
Mr. Hale hasn't appeared today.
No.
And have the two of you talked about what the long-term plan should be for the house?
Yes, I'm going to get my own mortgage on it and take his name off of it.
Okay. If you're both in agreement as to how property is to be divided,
Yes.
you can submit a consent judgment of divorce that simply spells out what you want to have done with the property. And I can grant that, provided you both consent to it. If
Okay.
not, I don't have files with me. I'm working from home this week because of a COVID case at the courthouse. And these files weren't available when I left on last week before Thanksgiving.
Right.
Do you know what your trial date is?
No, I just got today's date.
All right, hold on. I can pull it up. I gotta wake up this other computer first.
I'm sorry, sir. I do see it. It
Okay.
says December 17th at 1:20. It's right underneath this one.
Oh, okay.
I'm sorry.
So what I can do, presumably I'll be back in the courthouse on that date unless there are other cases that pop up at the courthouse. I haven't heard of.
Right.
And if you can get a consent judgment filled out, you should have gotten a blank
Okay.
judgment form and the paperwork that you got when you filed your case?
Okay. It's called a judgment form, judgment of divorce.
Yep. It
Okay,
will be
I got that.
blank.
Yes, I got that.
You need to fill that in with the case information. You need to
Okay,
check the boxes that say whether or not you want your maiden name or another name restored.
right.
Whether or not either of you are seeking any spousal support, typically not.
No,
Indicating that neither one of you is seeking any interest in the uh, life insurance, retirement plans, et cetera, of the other.
right.
And then you would spell out, there's a place that you already divided your personal property, if that's the case, and you'd check that.
Yes,
And then there's a box to check if whether or not you own real estate, and you would check yes. And then on the last page, there's a large area where you can spell out exactly what's going to happen with the house.
where it says other provisions, correct?
Yes, you would just write
Okay,
that
good.
in.
Okay, okay,
And if you can get him to consent to that, all you need to do is to submit that to the court. Once I see it, I can fill it out and sign it and grant your divorce. If not, if you can't get him to consent to it, you can still show up at this trial date and
okay.
I can take care of it then. So on the assumption that he's going to be willing to sign this, I'm going to
Yes, he will.
okay, I'm going to take some proofs today that will allow me to sign it. So I need to ask you to raise your right hand, please.
Okay,
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
Christy Joe Hale.
Ms. Hale, you filed a complaint for divorce a little more than 60 days ago or thereabouts. Was everything in that complaint true at the time that you filed it?
Yes, sir.
Can you confirm that there are no living minor children born or adopted during your marriage to Mr. Hale?
Yes.
Can you confirm that you are not pregnant today?
Oh, God, no. Yes, I am not.
And is there any possibility of you and Mr. Hale reconciling?
No, sir.
All right, I am satisfied based upon your testimony that there's been a breakdown in your marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage can be preserved. And if you get that consent judgment into me, I will sign it, and there would be no need for you to appear at that trial date.
Okay. I just have a question. I can do this because I'm doing this myself without an attorney. I can just take this, get him to sign it and take it to the court and give it to the court clerk, and they make sure you get it.
Yes.
Okay, like I did before. All right.
Exactly.
See the
Depending
girls in the
on,
basement.
well, depending on the status of the courthouse when you bring it in,
Right.
you may have to call the clerk's office ahead of time to make an appointment for someone to meet you at the door to get this from you.
Okay.
But yes,
Okay.
there's a way for this to happen.
All righty. Great. I will do that today.
Okay, very good. Have a good day, Miss Hale.
Okay. Thank you so much.
You're welcome. Bye-bye.
Bye-bye. No, I'm not divorced.
Not yet.
Not yet.
Okay. I'm guessing everybody left is on the MagSig matter. So I'm pretty sure I printed out a petition yesterday for find that. Yeah, here it is. All right, I'm going to let all of them in.
Good morning.
Good morning.
Okay, as soon as I have an audio connection with everyone.
Morning.
Good morning. Okay, looks like we've got everyone here. This is the matter of Magsig versus Magsig. I don't know who represents whom. Counsel, state your appearances, please.
Good morning, Your Honor. Andy Fleming on behalf of the petitioner Kelly Magzig. I just filed my appearance moments ago. Mick, I sent you a copy.
Sounds good. And Your Honor, Michael Fallahy on behalf of the respondent, Mr. Magzik.
All right, and the record should reflect that both Kelly Magsig and Joseph Magsig are also present. So this is a hearing to issue a PPO. So anything preliminary from either counsel?
No, Your Honor.
Judge, we haven't talked. I guess I would just suggest that there's a pending divorce between the parties as well. And since there's an open divorce file, I don't know if the parties are open to, or if you want to put us in a breakout room to discussing a mutual restraining order. I mean, I think there's been some conflict mutually between these parties, and we probably wouldn't be opposed to something like that, but I don't think a PPO is necessary in this case.
I would be willing, yeah, to talk about some parameters with Mr. Fallahy.
All right, let me put, let's see, how do I do this? Allow you to talk to your clients.
Are we on the live stream? We are.
We are, yes, but I can put you in a breakout room,
Okay.
let you talk, and then you can let yourselves out of that breakout room. But I don't think I can put you in multiple breakout rooms. So I'm not sure if you've got telephone numbers, you can simply call your respective clients.
Well, I think right now at this point, Mick and I could talk, and then we could call our clients and come back in. Is that
All right.
easier, Judge?
Yeah. Well, that's what I was going to suggest. I'll put them both in the waiting room.
Okay.
And I'll put the two of you in a breakout room. How's that?
Okay.
All right.
Sounds good. Thanks, Judge.
Okay, let's see. Breakout room. We're going to have one.
Okay. Joe.
Okay, so I'm going to put the two of you in the waiting room. So you don't have to sit here and look at a screen, and you'll still be able to see it on the YouTube. Well, I guess you'll only be able to see me, but anyway, we'll put you back in there. And when your attorneys are ready for me to call you back out, we'll call you back in.
Thank you.
You're welcome. All right, Shannon, at this point, I'm going to stop the live stream.